Hello viewers, in this lecture I will talk to you about competent parties. Section 11 of the Contract Act prescribes the parties who are competent to enter into contract. I will first read the section and then will explain. Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind, and is not disqualified from contracting by any law to which he is subject. Full stop. Friends, look here. Section begins with a very positive statement that every person is competent. It only limits 3 different branches from being competent to enter into contract. And which are those 3 branches? First is minor, second is insane, and third is when specially disqualified by law. Friends, who is minor? The Indian Majority Act 1875 says that a person domiciled in India is deemed to have attained majority on completion of 18 years of his age. So anyone who has completed 18 years is major according to Indian law. What the section says? These 3 categories of persons are not competent. A very interesting question arose when there are 2 different courses of decision whether the agreement with minor is void or voidable. Since in England they are voidable, one set of course prevailing in this country was that it is voidable. Another course said it is void. In this situation, in a very celebrated case of Mohini Bibi versus Dharmodas Ghosh, the case reached to the highest court, Privy Council, what is known in common parlance. And the Privy Council decided that you need not enter into this controversy as to void or voidable. Indian law is very clear. Section 11 categorically says that parties who are competent. The very interpretation of this section means that minor is incompetent to contract. And when minor is incompetent to contract, the agreement entered into by minor is void ab initio, right from its inception. It doesn't go to the status of contract. And therefore, since then, the position in India is very clear that agreement with minor is void ab initio. Friends, you all know that by entering into contract, you create a liability. And Section 11 prohibits minor from creating this liability, meaning thereby he cannot become a promisor. Does this mean that he cannot be a promisee? Or in other words, he cannot be a beneficiary? Obviously, that can't be the object of law, to deprive the minor of benefits. Therefore, you can very well say that if there is no liability, only receipt, only benefit, minor can always be a beneficiary. The glaring example of this is Section 30 of the Partnership Act, which categorically says that minor can be admitted to the benefits of partnership. It is he who, on attaining majority, has to elect whether to become or not to become partner. So during minority, he is admitted only to the benefits of partnership, simply a beneficiary. So there is nothing wrong in minor being promisee or beneficiary. Very interesting question arises that what happens when minor fraudulently represents as major and enters into contract. Very crucial situation. Ordinarily, one would answer that yes, representation is there, is to be accepted. Law says no. Minor can always plead minority. Even after representing falsely, minor can say that at the time of entering into agreement, he was minor. As such, in law, fraud vitiates everything. The minor has got this license to plead minority. And even if there has been false representation, the agreement with minor would be void ab initio. Equally, in this situation, the question arises that can we not raise the doctrine of estoppel against minor, meaning thereby, is he not stopped from denying the fact which he has said earlier? Here, he has earlier represented as major. Now, can he not be stopped from denying that fact that he is not major? Again, courts have held that no application of doctrine of estoppel against minor. If at all it is made applicable, what would be the result? It would have indirect effect of nullifying the provision of Section 11. Similarly, one more situation arises about ratification. Ratification is essentially a provision in the law of agency, meaning thereby when the act is committed, there is no authority, but subsequently the principal accepts that act. In short, you can say that ratification is a subsequent approval of the earlier act. Can a minor on becoming major not ratify the act done during minority? Again the answer is no. If during minority minor is incompetent, the same act cannot be ratified on attaining majority, because ratification could be only of a valid contract, and therefore there cannot be ratification of acts done during minority. One more situation also arises in this context about specific performance of contract. When minor enters into contract and the other party has to file a suit for specific performance, say for execution of sale deed and for delivery of property, possession of property. Can you file a suit for specific performance? Again the answer is no suit for specific performance can be filed against minor. The same logic applies, because if suit for specific performance is permitted, what would be the result? The result would be nullifying the provisions of Section 11 indirectly. And please remember, when law prohibits particular thing directly, it also takes care that indirectly also it is not permitted. Therefore, no suit for specific performance can be filed against minor. Similar is the situation about becoming guarantor. Can a minor become guarantor or surety? What is surety? Raising liability for the acts of another. The obvious answer is minor cannot be a surety, because he cannot make himself liable. Yes. One important deviation, that is about necessaries. And why? If necessaries are not permitted, the minor would be left to his own destitute and will have to suffer. So again, law has taken care that minor doesn't suffer because of no liability. And Section 68 of the Contract Act says that one who has supplied necessaries to minor according to his condition in life is entitled to recover the same, reimbursement of the same, from the estate of the minor. Here remember two things. Necessaries again are not prescribed. They depend on the facts and circumstances of the case and the station of minor in his life. A cycle could also be a necessary, or even a Mercedes could be a necessary. It all depends on the station of minor in his life. But what the supplier is entitled is only the actual necessaries required and nothing more, not the luxuries. And this is obviously for the protection of minor. One more important thing, whatever we have said here is about contract. What about tort? This is all about contractual liability. Minor is not absolved from the tortious liability. But yes, contractual liability cannot be converted into tortious liability and then say that yes, this is a liability in tort and therefore minor is liable. It is pure and simple tortious liability that minor is liable. Nothing more than that. Now friends, second important thing is, second category, the sound mind. What is sound mind? That is also defined. Section 12 of the Act. I will first read the section and then we will see. A person who is said to be of sound mind for the purpose of making a contract, if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. Full stop. Mark these two words very categorically. Is capable of understanding. And second, forming a rational judgment. Who is of sound mind? One who is capable of understanding what is agreeing, and again, what is the effect of that understanding on his own interest, and is he capable of forming a rational judgment. If these two conditions are satisfied, one is said to be of sound mind. And person with sound mind is competent to enter into contract. Friends, this section gives you a lesson for life also. It's not confined only to contract act. For any decision in your life, these two criterion, if you use and practice, remember me, you will never fail. First, understand what you are doing, capable of understanding. And second, form a rational judgment of what you are doing. If you ask me personally, most of the people fail on these two grounds. But we are not concerned with that so far as contract is concerned. So far as law of contract is concerned, it is sufficient if you establish these two things. The section further provides that a person who is usually of unsound mind but occasionally of sound mind, may make a contract when he is of sound mind. And further provides a person who is usually of sound mind but occasionally of unsound mind, may not make a contract when he is of unsound mind. Lunacy. Ordinarily man is sound, but during certain period he is not in a position to form a rational judgment. Intermittent period, which is in law known as lucid interval. Law says, yes, one is competent to enter into contract. It is only during the unsoundness of mind, during insanity, that one is unable to enter into contract. Look at the positiveness of law. Law wants, as far as possible, to enable you to enter into contract. And that is why even lucid interval is also accepted as capable being entering into contract. The third category is where person is specifically disqualified from entering into contract. The instant category is insolvent, against whom insolvency proceedings are pending till his discharge from these obligations, meaning thereby an undischarged insolvent. Law says he cannot enter into contract. So insolvent is against whom proceedings are pending, is positively disqualified by law from entering into contract. Thus, these are the three categories of persons who cannot enter into contract. The rest, every person is capable of entering into contract. Friends, in the next lecture, we'll talk about free consent, which is from section 13 to 20. Thank you.